The present appeal, my lord, has been directed against the judgment dated 6/9/17, my lord, NCWJC 9459 of 2011. If your lordship come to, my lord, the internal page 5 of that judgment, which is, my lord, attached with the memo of appeal at the end. This court is constrained to hold that the manner, I'm reading at internal page 5 at the bottom. Internal page 5, my lord, at the bottom of the judgment, lordship impugn. Yes. This court is constrained to hold that the manner in which the disciplinary authority has recorded the finding and imposed the punishment not permissible under law, where the inquiry officer has exonerated the petitioner of the charges leveled, particularly 13 charges. If the disciplinary authority wanted to disagree from the finding and record his own finding, it is incumbent upon the disciplinary authority to take note of the points of disagreement. The explanation submitted by the petitioner, evaluate the explanation in the backdrop of the finding recorded by the inquiry officer, discuss the same reasons for disagreement, and then record his independent finding. All the legal requirements are not adhered to by the disciplinary authority, and in one paragraph, order is not only so. And thereafter, my lord, at the last of that paragraph, this is enough to interfere into the matter, hold the action to be vitiated, allow this petition, and thereafter, next page, your lordship. Quast writ petition stands allowed, disposed of. Petitioner shall be entitled to consequential benefit in view of the efforts. Lord, the matter ought to have been, Lord, remanded back for fresh consideration, Lord, because of the technical reasons, your lordship, it has been, Lord, allowed. That is my.
But otherwise, what is the allegation?
Allegation, my lord, the petitioner happens to be the chief engineer, my lord, at the relevant point of time. In the year 2002, he was posted as chief engineer, Water Resources Department, Valmiki Nagar, West Champaran. And, my lord, on 23/7/2002, your lordship, the flux band at Gandak barrage, my lord, breach was caused, lordship, causing serious flood in the area.
Serious flood?
Flood in the area.
Correct. Is there any financial loss?
Pardon?
Financial loss caused to the state exchequer?
The public at large, yes, my lord, because, my lord, what?
That memo that there is a financial loss.
Lord, kindly come to page 68 of the writ petition, your lords. 68 of the writ petition, Lord. Not the.
1 second.
I'm sorry.
Loss or allegation that he has misappropriated. Court master.
Marker देखें थोड़ा.
CCR बोलो ना. bank, river bank. But to stay the people there.
Charge memo is dated which year?
20. It is, your lordship, 31/1/2003.
What is the age of the respondent? What is the age of the respondent as on
He
today?
had retired, lordship, on 31st of January 2003. 3. Lord, this is the case, Lord, wherein, Lord, perhaps lordship, Lord, may not like to exercise the power of equity because, Lord, because of the breach in the barrage, lordship, caused havoc, Lord, in this area. Lord,
Why he is alone held responsible? What about others?
others also are proceeded.
What happened to others? What executive engineer, superintendent engineer?
Respect to them, I cannot say.
What happened to them?
They have been.
In fact, you should have initiated joint inquiry. Why you held?
They have been proceeded, your lordship, because joint inquiry cannot be, Lord, because lordship, somebody junior engineer, somebody assistant,
All right, then you can't hold joint inquiry, and the rule provides for it.
and that's why, Lord, separately they have been proceeded. And here is the case, Lord, with respect to financial loss, Lord, only I will read, Lord.
But you have not determined financial loss because of the respondents' misconduct or misdeed. These are the financial loss cost to the state exchequer.
Only this much, Lord, perhaps that will persuade your lordship. At page 69, lordship, charge number 6, charge number 4. इसकी महत्ता के मद्देनजर त्वरित कार्रवाई जिन्होंने जानबूझकर इसलिए नहीं की कि भविष्य में बांध टूटने पर मरम्मती एवं व्यय का आधार बन सके जिससे इन्हें निजी लाभ हो सके। नीचे में है 6 में एफ्लक्स बांध दिनांक
Yes, Padre. Diametrically, it is not a case. It's not presumption, speculation. You should have initiated joint inquiry to find out each individual's role. What is that damage? Embankment. Yes, embankment or what? One.
Yes, Mr. State Council, we will not interfere. Only on the ground of timely. Time has sufficient time has already left.
नहीं रुका हुआ है
20 years.
अगर हाँ ठीक है जैसा आदेश होगा आई विल फॉलो। ये 100% विथहोल्डिंग ऑफ पेंशन का केस ये नहीं है।
No, it's all right, 25% pension. But you have not followed the procedure, no?
Your lordship, Lord, time without number has held, Lord.
No, we would have remanded the matter, but having regard to 20 years,
As you, Lord.
and there is no determination of financial loss.
Lord, this much has been said, Your Lordship, that intentionally with a view to earn money in respect of repair of band Number one. Number two, my lord,
Where is the finding of mens rea?
he is the chief engineer.
Correct, sir. Where is the finding mens rea? That is your speculation. Because of this, sir, in future he is going to earn.
Is there any?
No. Sorry, I failed to communicate. That is not only this. Charge is not only this. Charge is also there, my lord, that irrespective of the fact, my lord, that earlier he was directed to make repair or take action with respect to irregularity committed in the bond creation, your lordship. That was not done. That led to havoc in the public. Kindly see, my lord. Whatever amount, my lord, was spent on the creation of bond, my lord, that has been lost. And thereafter, again, your lordship, the liability has been created. Public at large has been made to suffer. Kindly, may I remind your lordship,
Where it has been mentioned in the charge memo that he was directed to repair that bunk and still he did not do it.
yes. At page 68, my lord. Kindly see, my lord, the date. विभिन्न at the top. विभिन्न बांधों के निरीक्षण कर उनके रख रखाव एवं मरम्मति के लिए सरकार को प्रतिवेदन प्रस्तुत करने हेतु जल संसाधन विभाग द्वारा गठित विशेषज्ञ समिति द्वारा दिनांक 23/1/2001 मच ईयरलियर को वाल्मीकि नगर स्थित गंडक बराज का निरीक्षण किया गया एवं स्थानीय पदाधिकारियों को मौखिक निर्देश दिया गया कि वे एफ्लेक्स बांध की समस्या की वस्तुस्थिति के संबंध में राज्य सरकार को अवगत कराते हुए एक प्रतिवेदन तैयार कर भेजें एवं इसमें गंगा बाढ़ नियंत्रण परिषद का नहीं आगे हमको थोड़ा सा पढ़ने दिया जाए। अगर यही इशू तो इतना ही है, 2 सेकंड और बर्बाद करेंगे समय है जो नहीं
present NPA.
serious damage to the public property, everything.
Correct. You should have taken timely action and you have not followed the CCA rule.
This CCA rule, not rather 1950 CCA rule is applicable.
Whatever it may be.
But my lord, here is the case, my lord, if the departmental head of the area, chief engineer happens to be in the my lord zone, and if the departmental head, my lord, after due inspection by the committee, my lord, is instructed to do something.
Sir, we would have remanded the matter just because the matter is 3 years back and he has already retired in 2003.
Thereafter, only, my lord, the proceeding has been started. On the date of retirement, his lordship, he was put under suspension. Thereafter, on the same day, because he was
Fag end of his service, you have taken, open your eyes.
on the date of retirement, kindly see the whatever has happened.
What is the date of punishment? 25% withholding of pension.
28/9/2005. Only 2 years thereafter.
Then why the writ was filed in 2011?
It was, my lord, 28/9/2005 in Extra 29 at page 308.
Filed in 2011. Thereafter, he has filed appeal, and you have taken 5 years to decide appeal. 6 years.
एक 29 का पेज नंबर क्या?
Appellate Authority Order is 6/4/2011. Cause of action accrued to him to file petition in 2011.
As you lordship please.
LP appellant state has filed the questioned the validity of the order of the learned single judge dated 6/9/2017, patch in CWJC 9459 of 2011. Respondent Mahendra Chaudhary was subjected to discipline on the allegations that due to his negligence during the flood embankment stated to have damaged resulted in havoc among the people at the relevant point of time, and so also state has suffered financial loss. In the departmental inquiry, he was exonerated.
Not of all charges. Charge number 1 proved, 14 proved, charge number 5 partly proved.
14 with
He was exonerated some of the charges.
Except charge
Charge number 2 and 14.
charge number 1,
14 and 5 were stated to have been proved. The disciplinary authority, while disagreeing with the unproved charge, proceeded to issue show cause notice and seeking respondent's explanation. On receipt of explanation of the respondent, proceeded to impose the penalty of withholding of 25% pension for a period of
entire period, 25% for all the.
on permanent basis. The Lord single judge has taken note of the order of the disciplinary authority as well as appellate authority that the points raised by the respondent against the show cause notice in disagreeing with the inquiring officer's finding that there were no analysis and finding on behalf of the disciplinary authority. The same was taken note of and set aside the order of the disciplinary authority as well as appellate authority order. Order of the learned single judge. Portion of the order of the learned single judge reads as under on page 5. Commences this court is constrained to hold till page 7. Next paragraph. No doubt it is a case for remand for consideration of respondent's explanation afresh by the disciplinary authority. However, we have already surpassed 2 decades and respondent has attained age of superannuation and retired from service in the year 2003. Further, we notice that financial loss has not been determined by the disciplinary authority while framing charges. In the light of these facts and circumstances, we are of the view that it is not a case for remand to the disciplinary authority to continue the disciplinary proceedings on the executive stage. Moreover, respondent has already undergone and suffered mentally facing the departmental inquiry and also litigations for the last 2 decades. Hence, the appellants have not made out a case so as to interfere with the order of the learned single judge. Accordingly, it is set aside. So, sub-concerned respondent is hereby directed to settle the monetary benefits of the respondent pursuant to the order of imposition of penalty and passing of the same, including applied authority order and pay the arrears of pension within a period of 4 months from the date of receipt of this order.
Take the phone. Lord, may I humbly pray one thing, Lord, because I being returning officer of the largest association of the High Court.
Huh?
My Lord, there is election, my Lord, it has been notified in Advocate Association, having, my Lord, no, I am returning officer, my Lord.
Huh?
I may be in difficulty up to 8th of April. And April,
Up to
8th of April.
date.
April.
Can't. We can
नहीं
accommodate.
नहीं आज आ गया आज हमारा स्क्रूटनी का है and I attended the court. It is not that I will be avoiding it. That whenever I need accommodation, Lord, please grant me, Lord.
We can accommodate it in 1 or 2 cases, not in every cases. Because you have to see the other side also, litigant.
I am not asking.
Sir, you ask your colleague to address the matter.
They are, my Lord.
If we find difficulty, we'll adjourn. But they should address the argument.
They will be, my Lord. In some cases, my Lord, I personally desire to appear. In those cases only, not in all cases.
And this is not the case. Senior counsel can argue the matter. Junior can argue the matter.
चीफ इंजीनियर पूरा बिहार को
So you with
पानी से बहा दिया और जो पब्लिक को हजूर को नहीं पता है उस एरिया में जो फ्लड आता है कभी जाएगा वेस्ट चंपारण तो वो एक नेपाल से एक नदी आती है फल्गु उसी से करके इरिगेशन का प्रोजेक्ट
Sir, timely action you should take. Otherwise,
वो रहम के लायक तो नहीं है बट जो ऑर्डर हुआ जो हुआ
6 years you have taken to decide appeal.
वो गलत है लेकिन वो
When are you going to rectify all those galats?
वो करने के लिए आई एम नॉट कॉम्पिटेंट
But you should put it in writing.
I used
Nothing harm.
to be